So we proceed with the Law on Secrecy of Bank Deposits, or the Republic Act 1405. Section 2 of the Law on Secrecy of Bank Deposits declares that all bank deposits of whatever nature with banks or banking institutions in the Philippines, including the investments in bonds issued by the government of the Philippines, its political subdivision, and its instrumentalities, are hereby considered as of an absolute confidential nature and may not be examined, inquired, or looked into by any person, government officials, bureau, or office except 1. In an examination made in the course of a special or general examination of a bank that is specifically authorized by the Monetary Board, after being satisfied that there is a reasonable ground to believe that a bank fraud or serious irregularity has been or is being committed, and that is necessary to look into the deposit to establish such fraud or irregularity. The important phrase here is the reasonable ground to believe that a bank fraud or serious irregularity has been or is being committed. So, remember the phrase reasonable ground. Number 2. In an examination made by independent auditor hired by the bank to conduct its regular audit, provided that the examination is for audit purposes only, and the result thereof shall be for the exclusive use of the bank. Number 3. Upon written permission of the depositor. Number 4. In cases of impeachment. Number 5. Upon order of a competent court in any case of bribery or dereliction of duty of public officials. 6. In cases where the money deposited or invested is the subject or the subject matter of the litigation. Number 7. In cases of unexplained wealth under RA number 3019. Number 8. An inquiry into bank deposits, trust or investment funds, or banking transaction when there is a reasonable ground to believe that they have been used in support or in furtherance of coup d'etat under RA 6832. So if the question provides for the following: under Republic Act number 1405, or the Bank Secrecy Law, bank deposits are considered absolute confidential and may not be examined, inquired, or looked into by person, government official, bureau of, or office. So, what are the exceptions? So, yung enumerated, the 8 instances enumerated are the exceptions. Exceptions are the instances where the bank deposits may now be examined by a person, the government, bureau, or the office. A bar question. Example: an employee of a large manufacturing firm earns a salary which is just a bit more than what he needs for a comfortable living. He is thus able to still maintain a 10,000 savings account, a 20,000 checking account, a 30,000 money market placement, and a 40,000 trust fund in a medium-sized commercial bank. State which of the above accounts are covered by the Law on Secrecy of Bank Deposits. The answer: only the savings, checking, and the trust fund are covered by the Law on Secrecy of Banking Deposits, as they are included in the explicit provisions stating all deposits of whatever nature with banks or banking institutions in the Philippines. The money market placement is not covered because it is not deposited in the bank. Question: what are the rules on secrecy of bank deposits under the existing law? The answer: the rules on secrecy of bank deposits are The deposits in banks, including government banks, cannot be inquired into by any person except in the following cases. 1. Where the depositor consents in writing. Number 2. Impeachment cases. 3. By court order in bribery or dereliction of duty cases against public officials. Number 4. Deposit is subject of litigation. And lastly, number 5. In anti-graft cases. Remember in the case of Melion versus Magsino, in a prosecution of unexplained wealth, the Sandigan Bayan may order the production of bank deposit records, not only of the wife and the children of the accused, but also those of his friends and cronies. Example. Question. X is a public official. He is charged with violation of anti-graft for unexplained wealth. The prosecuting official learned that X maintains a safety deposit box at Union Bank. May the officials of the bank be subpoenaed or examined about the safety deposit box? Yes or no? Why? The answer is yes. The officials of Union Bank may be subpoenaed and examined about the safety deposit box of X, who is the accused of the unexplained wealth. Under the law, a deposit in the safety box in a bank is a bank deposit. The non-disclosure of deposit law under RA 1405 includes all deposits of whatever nature with banks and banking institutions. The rule against non-disclosure provides an exemption where the depositor is accused in an anti-graft case. As the exception operates against X, his safety deposit box may be the subject of inquiry by the court trying him. Hence, the official of said bank may be subpoenaed for such purpose. Another question. The City Fiscal of Manila required the Manila Banking Corporation to produce at a hearing the records of the bank deposits of Alfredo Santos. The Manila Banking Corporation refused, alleging that the disclosure of the bank deposits is prohibited by RA 1405. Threatened with prosecution, the corporation filed an action for declaratory judgment. May the court compel Manila Banking Corporation to disclose the bank deposits of Alfredo Santos. Reason. The answer is this. I submit that the court cannot compel Manila Banking Corporation to disclose the bank deposits of Alfredo Santos before the Manila City Fiscal. Under Republic Act 1405, deposits in bank cannot be inquired into except in the cases provided therein. A city fiscal is not among those authorized to inquire into these deposits. There is no court case yet involving a bribery or dereliction of case against a public official. Neither is there a court case mentioned in the problem where the deposit is the subject of a litigation, which are only possible instances where a court can authorize inquiry into the bank deposits of a person like Alfredo Santos. Another question. Example. A secured a judgment by default against B for a sum of money. To satisfy the judgment, A sought the garnishment of the bank deposit of B with China Bank. The bank refused. May the writ of garnishment be issued against the bank deposit of B? The answer there is yes. The writ of garnishment may be issued against the bank deposit of B. The garnishment is merely an order to a bank to inform the court of the existence or non-existence of existence or non-existence of deposit, so that execution thereon could only follow. It is inconceivable for law to be used as a shield by the debtors who to evade payment of their debts would go through the motions of converting all of their assets into cash, deposit it in bank, and prevent creditors from reaching the deposited assets. Hence, the issue of writ of garnishment is proper in this case. So with regards to garnishment of deposits, including foreign deposits, okay, it is clear from the discussions of the Senate and the Committee on Bill, which eventually became RA 1405, that the prohibition against the examination of or inquiry into or of the bank deposit under the said law does not preclude it from being garnished to ensure satisfaction of judgment. Indeed, there is no real inquiry in such a case, and if the existence of the deposit is disclosed, the disclosure is purely incidental to the execution of the process. It is hard to conceive that it was never ever the intention of the Congress to enable debtors to evade payment of their just debts, even if ordered by the court, through the expedience of converting their assets into cash and depositing the same in a bank. This is the case of China versus Ortega, 49 SCRA 355. Remember, in the case of PCIB versus CA 193 SCRA 452, a writ of garnishment on bank deposit of a defendant is not an inquiry. Okay, it is not an inquiry into his deposit as contemplated by RA 1405. It is merely required by the bank cashier to inform the court whether or not said debtor has had a deposit in said bank, only for the purpose of the garnishment issued by it, so that the bank would hold the same intact and not allow any withdrawal until further orders. Okay, the prohibition against an examination of bank deposits does not preclude garnishment of the satisfaction of a judgment. Also, okay, the foreign currency deposits shall be exempt from attachment, garnishment, or any other orders or process of any court, legislative body, government agency, or administrative body whatsoever. Last example. I, a branch manager of a bank, in response to a notice of garnishment, discloses to the Sheriff of Pasig the outstanding deposit balance of judgment debtor Ray Sevilla with the bank as of the date of receipt of the aforementioned garnishment notice. Ray Sevilla files a criminal complaint with damages against the bank for disclosing his deposit balance without his consent, in violation of RA 1405, which absolutely prohibits the disclosure of any information concerning bank deposits. Would the complaint prosper? The answer there is no. Okay, the complaint will not prosper. The garnishment is not an inquiry into, remember again, garnishment is not an inquiry into the bank deposit of the defendant, but merely an order to the bank cashier to inform the court whether or not the defendant had a deposit therein, with the bank could order to be held intact until further orders. The disclosure of the deposit is purely incidental to the execution process, and certainly it was never the intention of the Congress to enable debtors to evade payment of their just debts by converting their assets into cash and depositing them in banks. The criminal complaint against the bank manager will therefore not prosper.